All right, so I want to welcome everybody that is on the call. Thank you so much for signing up. And I really think you are in for a big treat today as far as just information. I think that the whole topic of IRS enforcement, the IRS in general, tax policy, conservation easements is a good example of something that we can talk about in this area. So we are going to talk about that particular area in this webinar at a deeper extent that we'll talk about other types of tax legislation. But we're going to get a really good, unique perspective from several different people on this call. And the panelists have been asked to be as candid and objective as possible. There is no script on this, and so we are trying to get to the truth, the whole truth, nothing but the truth, but keep in mind that it's from people's different perspectives. So everybody has a different view of it. They're coming at it from a different angle and have had different experiences. So you'll have to keep in mind that in getting a lot of these perspectives, and we're trying to be as objective as possible, that we're trying to provide the most objective type of fact pattern and for anybody on this call to become a lot more educated on the topic in general. But just keep in mind that everybody has different perspectives, but I just think that this panel will give a fantastic overall perspective when you've kind of balanced it out all together, because a lot of these people are in the know. They have a lot of good experience in this area. And, you know, for one, I would use them and trust their opinion on a lot of things. And so I'm just passing that along to everybody on this call. Again, my name is Dan Lucas, and I am the host here, and I'll be mediating this panel. I am the founder and CEO of Credo CFOs and CFOs and CPAs, and we're a firm of fractional CFOs and CPAs. So we're very heavy into tax, along with supporting rising business owners and growing businesses. I also have with me here on the panel is Fenn Little. And Fenn is a partner in the Fenn Little Law Firm. His practice is concentrated in criminal defense, constitutional law, and personal injury litigation. He strives to protect the civil and constitutional rights of Americans charged with serious crimes. He has extensive courtroom experience in both trial and appellate courts. Next, I have Pete Sepp, and he is the president of the National Taxpayers Union Foundation. And as president of that nonprofit, nonpartisan National Taxpayers Union Foundation, he's an expert on such topics as congressional perquisites, is that right? And antitrust and competition regulation. He has testified before Congress, lectured in the US and abroad, and appeared on every major television network. And last but not least, we have Walt Ungerer, and he's a partner with Sandy Bay Partners. Walt has spent more than 24 years executing millions of direct investments, mergers and acquisitions, management carve-outs, and more. He's an active member of the Association for Corporate Growth and the National Investor Relations Institute. He's also a great tennis player, right? We like playing tennis in this group here. So, all right, so we have a lot of people on here, and probably just want to jump right into it because I'm sure they're anxious to get some of this information. So, Pete, I'm going to start with you, and I'd like you to give a little bit of your background, if you would, and kind of maybe tell us a little bit more about what your perspective is and what you see and like what, from where you're sitting, what you're able to see and observe as far as Congress, because I know you sit on Capitol Hill, as far as like Congress, lawmakers, what you're seeing in IRS enforcement, what, you know, and just kind of give people an idea of what perspective you're coming from. But then also after that, I want to lob over a question that is related to just taxpayers and how they're seen by the IRS, whether you think they're being treated negatively, why you think they're being treated negatively, and what you're seeing as far as some of the conservation easement legislation as an example of that. And if you can just talk to that a little bit, I'd appreciate that.
Okay, great. Thanks for having me here, Dan, and welcome to everyone who has joined us. I hope to learn a whole lot from you, and I hope you'll stay in touch after this, because you can play a very important part in our success here on Capitol Hill. So I've served with National Taxpayers Union for 33 of its 51 years. And one of our specialties in our mission is to look at how taxpayers are affected by the machinery of taxation. In other words, we can talk about rates and deductions and how to define the base for day after day, but what's also important is tax administration, how the bureaucracy interacts with taxpayers, how we understand compliance and complexity in the system, and how those all interact with the taxpayer's everyday experience. And to us, these are integral questions as to how our tax system functions, because if we focus solely on things like the Tax Cuts and Jobs Act, we're really missing at least half of the way our tax system is supposed to function, beginning with the Internal Revenue Service and collection due process, but extending into customer service and how rulemakings are developed. All of these things are vitally important to our tax system. And so we're proud to have a role on the tax administration side more than anything else. Now, a bit of background about me. I started out answering phones at NTU in 1988. And my second call, my second day on the job, was from a fellow who had called me up. I had to ask him his name several times because he couldn't get it out. He was actually sobbing on the phone. And he said to me, "I just can't handle my experience with the IRS anymore. They sent me a bill for $1,000 a couple of years ago. I've tried telling them I don't owe it. It's now past $5,000. I can't get a response from anybody. When I hang up with you, I'm going to end it all." And I realized, wow, suddenly my job that I thought was going to involve things like reading distribution tables or figuring out complex regulations got a lot more human. And from there on, I was privileged to be able to work on 5 separate pieces of IRS reform legislation, beginning way back in '88 with the Taxpayer Bill of Rights, extending until 2019 with Taxpayer First Act. And I was honored to have staffed our executive vice president back in 1997 with the National Commission on Restructuring the IRS. That panel's recommendations later became the basis of the IRS Restructuring and Reform Act, RRA 98. So from that perspective, and continuing into last year with the formation of our new public interest litigation arm called Taxpayer Defense Center, we've been taking an increased interest in the conservation easement space, because in our experience, what tends to precede all IRS reform efforts is really a 1-2 punch. First punch, the IRS either gets more resources to enforce tax laws or redirects its resources into enforcement from areas like customer service and information technology upgrades. The second punch is usually that the service finds a category or a couple of categories of taxpayers that are relatively small in number, but which present the IRS with an opportunity to expand some of its enforcement or examination or collection techniques. And so what ends up happening is really of a cyclical nature. We saw it in the late 1970s and early 80s, leading up to the '88 bill. We saw it in the mid 90s, leading up to the '96 and '98 bills. It simmered a while up through and until 2015. And then into 2019, the issues change. For example,
well, yeah. So Pete, when you say cyclical nature, are you talking about it's cyclical in what they are not targeting, but what they're focusing on, or is it cyclical as to maybe their drift from the taxpayer's bill of rights?
It's exactly, it's the latter. It's an historical trend. What happens is they get a bigger budget or more resources, then they find a group of taxpayers that troubles them in terms of their behavior, and they develop techniques to essentially enforce against those categories of taxpayers. And the trouble is, those techniques begin to get widely applicable throughout the system of tax administration. We can get into that later on in this session, but when you look at supervisor approval requirements for penalties, when you look at due process for appraisers, when you look at information document fact reviews, when you look at privilege between clients and advisors, when you look at the recently established Independent Office of Appeals, these issues that we're troubled by have been initially expressed in the context of conservation easements, but it's easy to see that they could be expanded into all kinds of other areas of tax law. If anyone out there who's participating in this is looking at opportunity zones or Law 2022 in Puerto Rico, where you have capital gains reductions, the IRS is going to use the same techniques that it has developed with CEs and migrate them into those areas. And pretty soon, not only large business and international division taxpayers are going to be worried, so are small business and self-employed. You know, again, I need to stop at the moment so that you can move on to others, but
no,
there's a lot here.
That's interesting, because I mean, that was good. A lot of times I'll get asked by clients, what, do you know if the IRS is targeting this or if the IRS is targeting that? And like you said, it's not necessarily the right question or a fair question to give them the right sense of what's going on, because it's more about the cycle. It's not necessarily the targeting something, it's their climate right now. It is their culture right now that has more to do with it. It's not necessarily what they're targeting, it's how they're targeting. If they're looking at something and the climate is good and we're in an up part of the cycle, let's say, then it could be that, hey, we do everything right, we're fine. You're going to have somebody who has Big Four experience maybe coming in. They're going to look at things. They're going to do it the right way. And all they care about is getting it right. So you'll be okay. Other times you can do something that is pretty simple and harmless. And just depending on how that goes, it can be a terrible experience. And it has to do with the climate of everything right now, right? Or the culture. So that being said, I mean, that kind of brings me over to Fen. I want to ask him a question. And so, Fen, I guess same thing as Pete, if you could just give a little bit of kind of where your perspective is coming from. I know that we've talked some and mentioned the class action suit that you're involved in. So I think that's out there. But I'd also like to know, as Pete was talking about how there's a drift. I see it as a drift away from the taxpayer bill of rights, as far as how close they are to actually following that. In substance or form. But I know that in your class action suit, you had a lot of specifics as far as not just talking about the drift in general, but very specific. And I know that you may not be at liberty to say everything, but if you could just give us, again, an idea of your perspective, of where you're kind of coming from to help the audience here, but then also, what are you seeing as far as the specifics? And can you talk to some of the things you're seeing in your suit? And is it really particular to conservation easement, or do you think it's going on in a lot of different tax mitigation plays that people are making?
I think it's to start with your last question and to follow what Pete was saying, because I think Pete's absolutely dead on that this has been going on for decades. Started back in the 70s with all the oil and gas, and the
Hmm.
same sort of process where the IRS gets more zealous about a particular congressional law. I mean, now we're up to the 170H, and they're the IRS doesn't like the way it works, so they're imposing. I'm sure a lot of people out there asking, what on earth is a criminal defense lawyer doing, in tax matters? And it all rose back when I guess the first one of these I got involved in was about 2014, when they were starting to put significant IDR requests on appraisers and bring them in for different types of things. And because of my criminal background, the federal agencies all use the same handbook for investigations. Just might as well. I mean, it's just, that's what they do. They have their same process of how it goes through there. And in the civil rights and constitutional law factor, the government typically has what's called sovereign immunity. Well, the way to get around that is when you have a ministerial actor such as the IRS, their job is actually to enforce and interpret, say, executive branch kind of thing. And then, but yet then they drift out of that and start making policy decisions. And I'm not saying policy decisions and how they interpret. I'm talking about usurping congressional intent. Once you cross that line, they lose that sovereign immunity. That's how way back when was about 2010, the Tea Party guys got some relief. It's a big part of the lawsuit we filed back in February. That they have crossed that line. That's how I got involved with defending the appraisers in these IDRs. We had one where they wanted a bunch of records, and this kind of brings us back to point. They wanted records they already had. And I see that over and over again. We need your appraisal. We need the operating agreements. We need and particularly with third parties, and I'm jumping a little ahead on the questions, but they use that because it's expensive. The first one we had, the first IDR I had with an appraiser, we went to the 11th Circuit twice when we filed a motion to quash. Now, which is, you can imagine how expensive that gets, and particularly with appraisers, they don't make the kind of money that some of the investors and other people do. I mean, appraisers typically in the early days, they were getting, less than $10,000 in appraisal. Now it's maybe closer to 50, but you're still, that's nowhere near the kind of money you can make in other I mean, if you have other roles.
Yep.
I mean, it doesn't take an attorney billing a whole bunch of hours to get over that. Or any of the sponsors. So they're the least able to defend themselves. If you look at, I mean, in just plain and simple language, they're just the least able. They don't have the resources. A lot nowadays, if you put together a syndicated, and that's IRS terms, that's not ours, it's a partnership. They're going to put back somewhere between $500,000 to $1 million for defense.
Yeah.
And that, well, versus, that's probably an appraiser's life savings. Somebody's been doing it a long time. And so that's where it comes from. And it's, just my opinion is rather overly aggressive. And I think that's why we've gotten as far as we have with this lawsuit. And other things. I think there's another couple, I know everybody's familiar with or it's heard, the Hancock County, where the courts actually dismissed it. But I think it was an ancillary mootness issue, not so much the anti-injunction, which CIC Services seems to have put us in a place to actually have some teeth there to stop the government getting out of control. Which I mean, I hope is the case, and we'll find out as litigation proceeds.
Yeah, it seems to be they don't. Well, whether they do or not, I guess I can't predict what they're thinking, but when they're doing this enforcement, it's almost like they don't realize how many people it touches, how many people it affects down the line, and reputations too. Reputations are hurt as well.
and it's interesting, some of the tactics they use, we've mentioned some with the making the decision before they even start doing any investigation, those sort of things. And this is just my opinion, but from what I'm seeing, to me, it's logical to see that they are not necessarily doing it to win, to get these taxes, but they're doing it to shut down the industry. Because if they can cause enough pain, people are going to get out.
Yep.
If it's too expensive, you're going to make a business decision. Look, it's not worth the return's not worth what I have to do.
Yeah, that sounds kind of antitrust. I think about a business where they'll, you be careful because if you're growing business, a tactic that they might use is to sue you out of business.
Yeah.
Right. You better have deep coffers because they can litigate you. They can litigate as a weapon.
Yeah, and ironically, the congressional intent behind the statute was to allow more people of somewhat lesser means to participate in conserving land and getting a tax deduction for it. And the IRS is making it virtually impossible for anyone except Ted Turner to be able to do it.
So what do you think
That's
about
exactly
that?
I'm sorry.
No,
well, that's exactly the question Judge Totenberg asked in the first hearing in the EcoVest Nancy Zach case. To stand there and she asked the government, she said, what's the difference between 10 neurosurgeons that make $1 million a year purchasing $10 million worth of property or investing in the controlling interest in a $10 million piece of property, or Ted Turner and taking the tax deductions, or Ted Turner and his immediate family doing the exact same thing where you just got one person? And the government could not answer that question because there really is no difference. A partnership is an entity just like you and myself and Pete and everybody else on this conference. We're all entities. Our businesses are entities. That's the way the law is set up. And the government, and I don't want to get ahead of everything, but my opinion and the way what I've seen, think about who pays the taxes.
Yeah.
What is it? It's something like 90% of the tax burden is people that make, between 300,000 and 3 million a year. So you knock out those guys from being able to take their deduction, and boom, they increase their money in very quickly, their revenue stream, because the big guys, the Ted Turners, they have other options. If you're doctors these days, and they're a good example, most of them get W-2s now. And you get a W-2 that's got $1 million and you don't have, half of Montana or half of the West to put in something and other avenues for deductions. The only thing you've got is your home mortgage interest payment and something like this, which has conserved hundreds of thousands of acres.
Yeah, so this doesn't, this whole thing, I'm trying to think of this logically. Maybe you guys have some thoughts on this, but if Biden's coming in saying the 30-30 plan, right? He wants to conserve 30% of the land by 2030. That's what it is. And they're trying to, the syndicated partnerships are now allowing quote unquote non-wealthy people to participate in this. Why so much scrutiny from it just seems like it's the opposite. I can see how they go after rich people. And so I understand that just inherently, but why would they target something that seemed to be helping the lower income people or middle class, so to speak, and something that is against the president's executive order? Like how do we make sense of that?
Some of that I think is a politically driven agenda from, unfortunately, within the IRS. That happens. A good book about how those kinds of political currents have carried away the IRS in the past is Power to Destroy by John Andrew. I can put that title in the chat box. It's an interesting book, well worth reading for folks who want to delve into that area of IRS history. But I think another is simply, and Fen can speak to this, when the IRS doesn't understand something that's going on in the economy, it reacts overzealously. And, you know, you see this in law enforcement as well. You can see it in cryptocurrency. You go to some of the hearings and watch them online with the commissioner struggling to define what cryptocurrency transactions are, how the agency is going to respond to it, what resources they're going to bear in policing those transactions, because at base, there's a lack of understanding as to what it is and how it works. And you see that in the conservation easement space with many of the IRS's engineers, as they call them, in looking at property values and conservation purposes. That's part of the problem. I mean, it starts with trying to understand that virtually all commercial real estate involves partnerships. It just does. It's mostly groups of people getting together to do something that's bigger than a house. I mean, that's about the
well, which is all
definition.
part of the basis of our economic prosperity, is the ability to syndicate, right? That's what our whole economy is based on.
Yeah.
You know?
Exactly.
Well, I think Pete hit it again on the head, that nail on the head again, when he was talking about lack of understanding. I don't believe, from all the IDRs I participated in, there's 5 criminal cases out there that involve conservation easements and well, and I've got clients in all but one of them. And so the investigation questions, the government, the IRS or their agents, are always coming back to the land and how can this land value be one thing different. They don't get the purpose that, if you're the investor LLC, it's more in line of first of you're renting. You're looking at the use of that land. You don't really own the land. It's separate. It's 2 separate things. It's kind of like whether you bought your office building or you rent from somebody. You have control of that building to use, so for your business. Versus if you own it, you've got the aspects of maintaining all that other kind of stuff. Sure, you can use it, but you can also rent it. You can do these other things. Well, if you've got your use here with those rights for this piece of land is in the investment group, and you forego that, you have lost your value in that. Goes from a lot of money down to really nothing. You'll see that in some of these class action suits that have been filed against the LLCs and the sponsors and the entities, that they're claiming, wait a minute, you can't sell that, turn around and sell that land. They already got what they, as renters, and I'm using that term as just trying to make it a little bit clear, they got what they needed. They were able to use that to further their business purpose, which was, from a tax perspective versus the other. So the IRS does not comprehend the separation of these two. All they do is see dirt. Well, they're farming it now. How can it be anything more than farm? And it's or it's timber or whatever, you take the pick. It doesn't matter what it's actually used for. They don't grasp it, and I don't mean they're not smart enough. I just mean nobody's ever walked them through it. It's confusing. A lot of people don't grasp it.
Yeah, no, I know, because I do business valuations. So valuation theory is not. I think you can apply the practices to various asset classes, to various things, and so we do the discounted cash flow and all that kind of stuff too. And so I look through at the appraisals, and to me it's, you have the appraisal, and then you have the other financial pieces of the transaction, and then you have this thing called, like, what people like to call a multiple, right? And I'm like, well, hey, the multiple is just a function of one divided by the other, and it doesn't mean that either of them aren't perfectly fine. They're both very innocent type of things, but it seems like, and even if you look at how they, they're hung up on the multiples, and I know this because there's evidence of, hey, if it is, if this multiple is above 2.5, then it's a listed transaction, et cetera, right? So they are hung up on it. There's evidence of that. But, why do you think they're so hung up on that? And really, I guess part of my question, it's hard to understand, is everybody kind of knows they're hung up on it. At the same time, it doesn't make a lot of sense to me, because if I value a company and it's sold for 8 times whatever, it is what it is. I mean, it's just a function of math.
Well,
So
yeah. And if you bought in at Microsoft's initial IPO, you'd be what, 25, 30 times richer per share.
yeah,
I mean, my boss, former boss, Jim Davidson, proposed in the 1990s, early 90s, that we sell all the land that the U.S. Embassy in Tokyo sat on, because it was worth $1,000 when it was built in 1945, but you know, worth like $25 billion by the time the 1990s hit. I mean, that's exactly the thing. And to your point, courts have been saying that they don't agree with the IRS's opinion, and that's one reason why the service has shifted its strategy away from these zero valuation arguments based on appraisal and going to, well, there's something wrong with the amendment clause or the extinguishment of proceeds clause or something else in the easement agreement, so the whole deal is scotched. And that is an exotic litigation strategy, and one that the National Taxpayer Advocate that we lobbied for, and many others did in the laws back in the 1990s, has been saying recently in her annual reports to Congress, look, there ought to be a safe harbor developed for what constitutes a legitimate conservation easement agreement. We can all agree on that. We can end these so-called foot fault issues, and everybody will know where they stand. And a coalition of organizations, mine included, wrote to Secretary Yellen earlier this year, because she said in a hearing, that sounds like a good idea. And we said, yeah, it is a good idea. Why don't you pursue it? Haven't gotten very far there, unfortunately.
yeah, and I've seen a lot of that too. I mean, as far as just the general attitude, it's hey, if we're doing, and this is not just conservation, it could be anything. It's like, look, we think we're following the law as written to a T, right? If we're doing something wrong, give us some clarity and we'll change. We'll do it differently or whatever. We just want to follow the law. But we're not getting a lot of guidance as far as what I've seen in that area, which is very unfortunate. But I think so. The attitude is there to do things the right way, but it's almost like it's falling on deaf ears. Okay, which makes sense based on what you guys have said. But do you guys see any bills or any new legislation or any chatter coming down the pike that will change the rules or clarify anything and make any of this better? Is there anything that we can look forward to, or something that's being discussed out there?
You should go first, Fen.
Are you going to put it on me? Thanks. There is some things that we've been talking to a couple of people in Congress, and this would be, I guess I can label myself more sort of the litigation end, but from things we've seen, we've reached out to a couple of members on both sides of the aisle, actually, that wait a minute, if the goal here, which is what the stated purpose of 178, is to conserve land, it's been very successful, and you can't conserve land without some private participation. I've got just happened to have been on the board of a charity, a Christian charity years ago, but the person that was on the board with me and was the chairman part of the time when I was there is one of the largest timber companies in the U.S.'s head of conservation. And he said, we were at lunch one day and we were talking about these. I think it was probably about the first time we were dealing with them, and said, Finn, you wouldn't believe the numbers of acres that we have tried to give both the federal and the state governments for conservation. I mean, the timber would have been cut, but we're going to give you this land, and they would turn it down because they had no resources, didn't have the budget to manage it. Yep. And that's what you get when you put in the private sector. There are endowments. There are ways to manage this property and make sure that it actually does benefit the public at large. And the benefit can be incredible. We did a research, had a researched 1,000 acres of pine tree timberland in middle Georgia, not exactly booming metropolis of the world. The public value for that, and this is from the academics, this isn't from Finn's lawyering. This is was $4.2 million per year in carbon, clean air, water, all the benefits to the public at large. You go perpetuity, which they're talking about, but you even go 30 years, that's $120 million. That's a lot of money. And this particular one took less than 50 million in a deduction. So the government's getting a heck of a deal. And they didn't have to manage it. They didn't have to do anything. And the public's getting and I think that's what Congress was looking at when this law was put into place, the 170H. What I see is things in the criminal world, which is where I spent so many years, mandatory minimums have ended up being a complete disaster. You've got the same problem with these. Okay, what's the multiplier going to be? 2.5, which is basically a dollar for dollar tax deduction if you're in the 40% bracket, or is it going to be 4 or 6? Well, that's a case by case thing. It change. Everyone is different. Just like your Microsoft, example, Pete. That you if you bought into Microsoft back in the day, you're 30 to 1, at least.
Yep.
There's others. Some of the .com days. You couldn't. You might not have. You might not. You would have been better off buying a case of Budweiser and turning the cans in, and you'd have more money at the end. But bad example. But the point being is, every case is different, and that's why I think we need some sort of legislation that either helps move some of this, maybe delay certain amounts to see how much benefit it really does to the public over time, or some sort of checkbox, because we're getting no direction. Just like Pete brought up, we're getting no direction from the IRS. Even an opinion letter has no value. I mean, they can change it next day, and so nobody has any idea how to make this work and make it work.
Yeah.
Well.
Yeah, and I think that legislatively, of course, most people in this space know about the very recently reintroduced Conservation Easement Program Integrity Act from Senator Daines, and that has the 2.5 times formula in there, severe retroactivity, essentially going back to when the so-called listed transaction notice was issued on partnership conservation easements. And there's a new nasty penalty in there that essentially says that anything over the valuation limit is deemed to be subject to what's called the gross misstatement penalty. And that's essentially upping the ante on taxpayers claiming the deduction. On the other hand, there are positive pieces of legislation. Senator Cornyn has introduced a bill called the Small Business Taxpayer Bill of Rights Act. And even though it has small business in the name, there are a lot of good provisions in there that would apply to all types of taxpayers, limits on ex parte communications, and setting up an alternative dispute resolution process that can actually work inside the IRS. Unfortunately, other countries with systems somewhat similar to our income tax system have had much better experience with ADR, like UK, Australia, New Zealand. We have not done much at the federal level in utilizing that tool for tax disputes. You see it more at the state level with tax tribunals and other types of processes, but we could do a much better job on that. And I think that would do a lot to lessen some of the tax court's load and allow people with more limited means to get some kind of resolution to their tax problems without having to pay a whole lot of money in tax court to do it.
Yeah.
There's also some legislation from previous Congresses Senator Grassley had the Taxpayer Bill of Rights Enhancement Act, TBOR-E, that would enhance a lot, as its name implies, a lot of the protections that we've been able to enshrine in law since the 80s. So there is some hope here. And which laws make it depend a lot on expert input, especially the people participating in this event. Those of you who are watching this, you are all, I can tell by some of the folks' comments in the chat box, you are all eminently qualified to reach out to your lawmakers about these issues and make sure that the right legislation bubbles its way up into the process. When they're talking about increasing the IRS's budget to the degree they are now, those are precisely the kinds of guardrails we need to be talking about at the same time.
Yeah, well, you think it'd be just as simple as them following the IRS Taxpayer Bill of Rights, but it doesn't seem to be that simple, unfortunately. But that being said, we talked about this. You were talking earlier, Pete, about the cycles or the cycle that it goes through, the Internal Revenue Service, or any agency for that matter. But specifically to the IRS, is it? I mean, you know, we can talk about what's going on, but at the end of the day, it's okay. In practical terms, if I am in something that's, maybe let's just say I'm in a listed transaction, or I'm in a specific tax strategy that seems to be getting more attention than others, what, you know, is there hope? Is the cycle, is it going to swing the other way in 20 years? Is it 2 years? You know, is it likely that this is about as bad as it's going to get, or do you think it's going to get worse before it gets better? You know, and then, or is it that, well, it may not get better, but they might just switch and start looking at other things? That's probably more likely than a pendulum swing. Like, what do you see like in the next maybe 2 years or 5 years as far as the climate and culture at the IRS?
Well,
I'm asking you to speculate, but you know.
Yeah, I'd be interested in Fenn's views too, especially because he's litigating a lot of these issues. But, you know, like anything in the tax world, the answer is it depends. And one big factor is, how will some of the key parts of the litigation process go for taxpayers in the next couple of years? We've got that Oakbrook case out there, which has to do with whether the Administrative Procedure Act has to be used with forms of IRS guidance that essentially rewrite the IRS's opinion and then say, you should have known what our opinion was going to be when it was rewritten 6 years prior. I mean, that's, you know, we also have to see how that CIC services case, which narrowed somewhat the IRS's ability to hide behind the Anti-Injunction Act in saying taxpayers can't enjoin us from doing something before we do it. The 9-0 ruling from the Supreme Court, and we, along with probably a dozen others, filed friend of the court briefs in that case. It still has other litigation out there that we need to try and refine that ruling and figure out how much it will apply to other types of situations. And we recently filed in a case in New York that we think might present an opportunity. This is regarding what the governor and the legislature there described as a penalty on opioid manufacturers of all things, and set aside who it is, and you got to do that in these kinds of cases. But when elected officials say, we're not levying a tax here, really, we're just levying a penalty on behavior, well, the CIC services case was about that, whether a penalty is something that the IRS can creatively employ the Anti-Injunction Act against. Well, this is the next test of that ruling to see, okay, here's a state trying to get away with the same thing. Are we going to allow that to happen? And if the court rules favorably there, you can bet it's headed to the Supreme Court. I'll bet you. It has to. But these are the types of things you do in litigation, as Fen can attest. You got to look for your opportunities.
And there are some Eighth Amendment issues out there. We mentioned it in our lawsuit, but there's a pretty good Supreme Court case, and the name escapes me, though I put it in the complaint, that actually says that a civil penalty can fall under Eighth Amendment cruel and unusual punishment grounds. So that's in line with the CIC. Now you've got to meet all the criteria that you would if it was a criminal penalty. But some of these things where there's no basis and they're just kind of unilaterally putting out these penalties without any due process of any sort, any hearings, any real investigations, I think those are right. And I've also seen in the litigation coming down that when it gets past the football, it's just like Pete mentioned earlier, they've kind of gotten away from that because they've been chipped away for administrative procedures. But when the focus is on conservation purpose, the courts of appeals have been very favorable to when you got I don't want to use this word, a very strong, instead I was fixing to say crazy good, but it's so much for my education. But anyway, a very strong, extremely strong conservation purpose. I go to the Champions Retreat. I always use that as an example. You had a golf course that was actually operating on the Savannah River outside of Augusta. They shut down the last 9 holes of the golf course and let it go back natural and put it in a conservation easement. And it's a beautiful stretch. It's right there in the shoals where the fault line and everything. And it's a nice piece. I mean, it really makes a difference along that river. Well, the 11th Circuit upheld that. They said this, they upheld everything on that case. And it was because the conservation easement, the conservation purpose was so strong. It was clear that you had that this property needed to be conserved. And this you did not need anybody coming in. You didn't want the golf course back. You didn't want condos along that stretch of the river. You wanted, this was going to be a benefit to the public for in perpetuity.
Yeah.
Those are the kind of cases that the tax court won't necessarily go with us, but we've had a couple of positive ones. But the circuit courts, where they're looking at more of the public policy and the bigger picture, the courts of appeals have been very much in our favor, where we've had a strong conservation purpose. We're seeing more from the tax courts as well. I think they're starting to understand the separation between the land and the purpose here, the investor purpose. I always call it the PropCo and the InvestCo. The investors, that there is the valuation is not just the dirt. They're really starting to grasp.
Well, and it's not written in the law that way.
It's not. The law. The law is the law, and that's part of what we filed. And I think the IRS doesn't get is, wait a minute, your job, Mr. IRS, is to follow and implement the law, not to change the law to fit your determination of what it is. And that's kind of the $1 million battle or question that we're in is, will the IRS accept the fact that their job is to follow the law, not create the law?
Yep. Yeah. And that's sort of, that kind of makes me think about, well, if they can go, you can go through the court, right, appeal, and there's favorable rulings. It always seems like that as you keep going down the line, you get more and more reasonable, logical sort of thinking and decisions. And a lot of them are favorable. Problem is it's very expensive. Yeah. But when I'm looking at, my understanding is like for 2016 and maybe some other years, so I'm not for sure on this, that they have selected every project for examination. And it's like, how in the world are they going to be able to take all of these through appeals? And I just don't, do they have the resources to do that? And then what happens? Because I think, you look at it on one side is on the economic side, people know that they're going to have to, spend legal fees on this. It's just kind of something they're going into it with, but they have the funding. And so I'm looking at it like, how can all of these, if they do 16, 17, 18, 19, how can they possibly work all of these through the court system? And assuming that they can't, how do you think this is all going to end up? I mean, how do you think all these things under audit are going to end up? I mean, do you have any idea of what you would put, what would you bet on if you had to bet on an outcome to all of this stuff for the conservation easement audits?
I think it's a matter of survival from the litigation perspective, and we've got to come up from our side a way to streamline the litigation and it not be bankrupt everybody. And you can do that. I mean, but you have to be, I mean, years ago, if you did a real estate, if you were going to buy a house, it was a lot more expensive. Now they have more form basis and how to proceed along those lines and keep the cost down at the early aspect. And in the minute you get the first audit, you need to be figuring, okay, we're going to if not the U.S. Supreme Court, at least to a circuit court of appeals. And let's plan ahead and be ready for that. And let's go towards that goal, because the government, I'll probably get myself in a big mess for saying this, because there's probably some AUSA out there that's heard it, or a judge. But I've said this for years. The government is more afraid, and I say this, any prosecutor, IRS, it doesn't matter. They're more afraid of losing than they are determined to win. As business people, our job is to get out there in the marketplace and succeed. Theirs is to keep from losing.
Well, see, that's what worries me, is you see the court, they can't keep losing in court, because that just opens the door up, right?
Right. So they'll resolve it. And I only know about in the Atlanta division of the tax court, where the tax court judges have come in and tried here, there's some 80 cases that are open right now. You're looking at that with COVID and everything else. We're now getting criminal cases, which are top priority in the Northern District of Georgia, scheduled for 2022, late in 2022. So that's, and everything else, the civil cases come behind it, the whatnot. The Nancy Zach Ecovest case is probably the first one. Well, Judge Totenberg has 39 of those. Some of you may have heard the Sterico or something like they were doing sterilization and stuff leaked in the atmosphere. There was a plant in Cobb County, they're all 39 cases going to trial in front of Judge Totenberg. So it's going to be a long time.
Yeah.
And all the rest of the judges are the same. I just happen to know that specifically because I've had a lot of cases in front of her, and the backlog is unbelievable. Part of it because of everything getting taken to litigation. So they're going to have to come up with some other means. And that's why I was encouraged. We recently, I think I already mentioned this, but we have 2 cases now that we filed a petition where the IRS attorneys actually reached out to us about going back to appeals. I'm hoping that they're going to start evaluating cases in their own right. Hey, which ones are we going to chance to win, and which ones do we need to resolve outside of litigation? Let's make this work. I would love if we could come up with some legitimate IDR kind of process. I believe Pete, once again, started off with this, that would help get a neutral to sort through and explain to both sides where we're heading and try to resolve it. It would be in everybody's best interest, because the poor taxpayers get hammered if they get these, the settlement thing says 40% penalty if you're involved in it, 10% if you had no, basically you were just strictly an investor. But if you had invested in set multiple, you may very well fall into that 40% because they claim you knew. And plus, all you get is the money you actually put in is the only deduction you get. So that's, it's not much of a setup.
Got it, yeah. So in your opinion, if you have, and I mean, again, it's just in your opinion, if you have enough resources to, be patient and take this all the way through, is that your best, is that your best plan right now? If let's just say you either are a plan sponsor or even just being a participant, a member in one of these LLCs, is it, do you say, hey, look, your best bet right now is to let it play out, and get in front of somebody logical, or is there something else? I mean, I think, what's the practical takeaway for somebody who is maybe wanting to participate in these things, wanting to see land conserved, but they hear us talk about criminal stuff and this and that and stuff, and so it might spook them, and maybe it should spook them, because maybe I want an honest answer, as to what you really think. But I mean, should they be worried about something? Should they just be patient? What do you think? I mean, what's your opinion on what you should do if you're just somebody who wants to get involved in these and you like investing in these things?
Well, my crystal ball's in the shop right now, so I can't really, back to Pete. Yeah. I like to follow Pete. It depends. But the key, my personal best opinion I can give, if you're going to get involved with whatever level, you need to do exponential due diligence. I mean, you want to make sure that not only are all the documents in order, but you need to make sure that land has some real conservation purpose. You need to make sure that the investors all of them have really looked into what we're getting into and realize it could be a battle for a long time. And most likely, I think things are going to have to start settling out other than regular litigation through the courts. It's just too long. And you also have to have a plan for when that litigation. Are we going to go drop $1 million retainer on certain? I mean, some groups charge that. Or are we going to find, okay, how can we do a cost benefit analysis and keep these litigation expenses under control so that we can continue the fight? I'm a sort of a history nut. George Washington won 2 battles in the Revolutionary War. 2. But he basically fought a guerrilla war, and we sort of have to do the same thing. I mean, he won it at Yorktown. He won, there at New Jersey, the Delaware deal. That's it. He lost everything else, but he kept his army intact, and he won. And the part of that was avoiding the slaughter, and that's what we want to do. And the IRS's best method for slaughtering us is getting us into protracted, extremely expensive litigation where you've got discovery that's over and over and over. Sometimes it may be necessary to, put a motion to, petition to quash the subpoena. But sometimes it's just easier. Hey, here's the records. Bury them in paperwork. Just keep giving, because most of the people that put these together, there's always a bad apple or two, but most of the people do they don't want to have to fight this stuff. So they're going to bend over backwards to do it right, make sure the appraisers have not been unduly influenced, make sure all the numbers are correct, and do it like the law says. Because if you don't, that's where you get yourself in that's where the guys with the orange jumpsuit and the badges and the guns start coming in, is, you start backdating documents. That's what happened to the North Carolina guys, is they backdated, they took the money in after everything was closed. Yeah. I mean,
that's what I've always said too. I mean, I don't, again, this whole thing, don't have a crystal ball. It depends is one of the most famous phrases for many accountants, right? Or CPA. And it's true, a lot of times it does depend. But, I've always told people, like, hey, and I think this goes for a lot of private investments. Just think about the worst case scenario. And, if you think it might rain, bring an umbrella. Like, don't worry, don't try to speculate where it's going to rain or not. Just assume it's going to go all the way to the Supreme Court. Make sure that the chance of capital calls are low. Make sure you're technically sound, and make sure that your only risk is really, it's not a technical legal issue, right? And it's not a money issue. It's stuff out of your control completely, right? And that's all you can do, because there's no such thing as no risk, right?
My father was a lawyer in small town Georgia, and he was close friends with Bobby Lee Cook, who's one of the most well-known, Matlock Bobby Lee Cook.
Oh yeah.
And I remember sitting at lunch. I was carrying briefcases or something, and I asked him, "How do you win all these cases, Mr. Cook?" He looked over me in that sort of nasal North Georgia mountain twang and says, "Client selection, Finn, client selection." And it's the same with picking your investments. You've got to pick the clients or the investments that are going to be the most defendable and the best. It may not be the ones with the biggest return. it may be the ones that have the most solid conservation purpose. They've got a great marketing plan. It's got all these other aspects. I mean, you have to sign to invest that you're a sophisticated investor. Well, you need to be a sophisticated investor and actually do that part of it. And ask your client, your accountants, your lawyers, whoever's helping you, ask them hard questions. Some of the things we've talked about here in this seminar. You know, what's going to happen when IRS just gives us a zero valuation, just out of the blue? What's going to happen? How do we deal with this? And the information's out there. We've got hundreds of they go by their forms. I mean, their offer for settlement's always the same. And and they'll always tell you this is the best settlement you're ever going to get. I've probably done 300 criminal cases or in the Northern District of Georgia over the last 30 years. I always get the first offer saying this is the best offer you're going to get. It's never been. Now that doesn't mean the first time may be next week, but you got to use your educate. I mean,
some of it's just old school negotiation, right? It's not specifically patented by the IRS.
No, it's been going on for before I had gray hair, but it's just
let me jump in real quick. I've been quiet because I'd much rather be talking about oil, dirt, and endangered species than tax. So, but yeah, on the due diligence stuff, additional items to what y'all are suggesting, you want to look at who the law firm is and what their experience is in pulling together the PPM and the due diligence. You want to look at, does the law firm hire the appraiser, or does the entity where you're the sponsor, do they hire the appraiser? What kind of interaction they have? Some firms, there's zero interaction between the sponsor and the appraiser because all that's done through the law firm. It's similar with the geologist. Who's the geologist, and who hires the geologist? Who could influence the geologist? We always laugh about, Ted Turner when he hires his appraiser, and this is a joke. I'm not no liable here or anything like that. But Ted Turner has his best buddy from down the road come over and said, "Hey, I just bought this $50 million tract of land. What do you think it's worth?" And and that's undue influence coming from him. So that's an area of due diligence that you want to focus on. What law firms pulling together PPMs? Who's actually doing the closings? Who's touching the money? Is there a managing broker dealer involved? Or is who's breaking escrow? Who's the landowner, and what's their operating experience in that highest business use? So do you have a landowner, for instance, if you're conserving land with oil below it, what kind of experience does that particular landowner have operating oil wells? And how long has he owned that land? Those are the types of questions you want to look into, what their experience is in the highest and best use as an operator. And I think that, who the land trust is, who's going to manage the land trust in perpetuity and so forth. So how well are they funded and so forth, how the deeds get filed and so on and so forth. So just additional ideas, I think, to think about as you're doing your due diligence on sponsors and their transaction.
Yeah, well said. Very well said. You guys got any comments on that, Pete or Fenn?
Just agree 110%. And I do think that looking into all the different players from the land trust to the landowner is very important. Look at the nuance. How many times have they been participated? How many times have they been recently under audit and been cleared? Those sort of things, because every land trust is getting audited right in the last couple of years. They're all getting audited.
Yeah.
Some of them come out clean. Some of them are litigation forever that never did anything wrong. They're just going to get pummeled because they have a target. But it's look at those deeper questions. Don't just read the document. How many of us have signed important documents that we read the first paragraph and then signed? I mean, you really have to do the work. Or you're going to end up spending some money.
So people and that actually makes me think about some of the overreach where if they're pulling the project land trust for audit, and then they actually go into the partners asking for information. Sometimes I've seen requests for information. Sometimes it comes in the form of a subpoena. I think a question that I get a lot is, at what point do I seek counsel? Like, at what point do I seek representation in that process? Because a lot of times it's like, it's harmless. And it's like, well, hey, I want to see every email that you've gotten from Dan or something. And it's like, well, okay, fine. Not, you know, but it's like, but if you're dealing with an actor on the other side that you're not really sure what the motives are, when do you guys say, well, of course, I know you have to be a conservative as far as giving an answer, but I mean, is it, if I get a subpoena, is that like, you better get counsel, or is it before that? I mean, what do you guys think? What's your opinion on that? Probably posing this to Fen.
Yeah, well, of course, I'm a lawyer. Of course, you need to call me the first day you ever get anything and send our big retainer.
As soon as the IRS looks at you, yeah, no, I get it, yeah.
Most of the stuff the individuals can handle themselves. The big advantage I see to having a lawyer involved early is it gives you somebody to blame. You can always, if you say, okay, we're not sending these because these documents are privileged. My lawyer told me I can't send these. And then the law, you know, and that kind of puts it into a step back. And sometimes I've seen with people getting sort of ridiculous summons and subpoenas, and they want every email you ever did in the last 100 years.
Oh, yeah.
They want everything I mean, it's crazy. And they can get it eventually. They're gonna be able to get to it. You can file a motion to quash or petition to quash. Typically, and I can only speak to the Northern District of Georgia, but it's pretty much the same. The courts are going to bend over backwards to let them get that information. So what you want to do is be somewhat cooperative, as cooperative as you can, but firm. Back to the barium and paperwork. We had one, we sent it was a terabyte hard drive, and it was stuff they already had. Yeah. But it was easier for us to stick it on a hard drive and send it to them and say, y'all spend the next 6 years digging through it, have fun. than it was, you know, to fight it was going to cost the client a ton of money versus copying it all onto a hard drive that a paralegal can do. So it's really a business cost benefit analysis, strategic process. And if you've got people there in your own organization that can help you do that, that's fine. But sometimes having a separate person, whether it be an accountant or a lawyer or some combination, is worth the time. And at that stage, it's not crazy expensive, at least with most people. It's probably worth the time to have to have that other set of eyes on it, and that evaluation. And it doesn't necessarily have to be a tax lawyer or your corporate counsel or your own personal lawyer can probably help you through that with a phone call to somebody that's maybe done more of it and say, hey, let's put this together. I've had experiences with people that had, in-house counsel and whatnot, a couple of phone calls, and we put stuff together, and, sometimes a quick review, and it was able to get the information there. They've never heard again. Never got anything else, particularly I'm talking the taxpayer investor level here. The people that are more involved are just going to get hounded. They're going to get left in the IRS for the rest of their lives.
Yep.
Well, and if you're really going to get this far into a process where you're investing significant amounts of money and you're concerned, one of the best things I think you can do is arm yourself with some additional information that will allow you to sift through what might or might not be a very serious situation. I, for example, every time I get an email from a fellow named Hale Shepard, I instantly open the attachment. Hale Shepard is probably the foremost commentator, analyst, expert on various tax enforcement and administration matters, but particularly conservation easement matters. And if you open one of his articles and you say, hey, gee, that looks a lot like my situation, run, do not walk to a tax advisor.
Yeah, and it's hard not to be safer than sorry, right, in this kind of environment. But I did want to quickly switch gears back to something we were talking about a little earlier, because I saw someone had sent a question in. as it relates to the legislation, I mean, I've seen so many, I mean, I've seen some marker bills go in and some crazy things. And I've seen, you know, different bills that are kind of floated out there. I mean, I saw one about a seasoning period. Of course, we've talked about the 2.5 times limit. What do you, I mean, do you think that, you know, there is a reasonable or reasonably possible chance that one of these pieces of legislation is going to go through? I'm especially disturbed by the whole retroactive thing, not just because necessarily, well, because of the topic we're talking about, but just in general, as if they start to legislate retroactive tax treatment, and it's a precedent. That to me is a huge problem. I can't even fathom something like that. I mean, is that something that's even possible? Well, I mean, I know it's possible, but I mean, is that realistically possible, or is that just something that's going to get struck down? I mean, in your opinion?
Oh, it is possible. And a court challenge based on retroactivity is something that our own Taxpayer Defense Center has been contemplating for quite some time. And the Supreme Court and other court jurisprudence suggests that certain types of retroactivity get upheld, especially in the civil area, and certain periods of retroactivity get upheld. Now, the strike against, for example, the Conservation Easement Program Integrity Act, is it's taking a retroactivity period going back 6 years. That's fairly rare. I mean, 1 year, 2 years is more likely. And the fact with the IRS's own audit strategy, I mean, all audits are in a sense backward looking. They're looking at past behavior, but they're looking at the past behavior supposedly in the context of a fixed law. the service can't say, we're investigating you for something you did 5 years ago, and we're using a different interpretation of the law as it existed 5 years ago, and you should have known about that.
Yeah, that was kind of my question. I mean, is it that they say, hey, we, you know, is a simple example, you know, Congress decided they don't like mortgage interest anymore. And so we're not going to let you deduct it. And we're going to make that law, we're going to make that retroactive 5 years ago. So everybody that's deducted mortgage interest in the last 5 years, you have penalties and interest. Like I guess it's not like retroactive as far as applying the law as written and interpreting it and going back. Because I think I can understand that, but it's more of, would they actually materially change the law like that and just pull the rug out from underneath people?
Yeah, well, that has various factors coming into play. Things like if an agency does it, there's what's called Chevron deference doctrine, which says an agency has a degree of latitude as to how it interprets a statute. Well, and there were also in the latter half of the Trump administration, a pair of executive orders about guidance and avoiding what's called the doctrine of unfair surprise. Jenny Johnson Ware, an attorney, has written extensively on that topic and has done a very good job. You know, to the question that was asked of us in the chat, what's the prediction on my part? I'd give it a 60% chance that something happens in this Congress. One of the primary motivations for passing something here and making it retroactive in the CE space is revenue. If Congress were to pass a law tomorrow limiting the multiple to 2.5 for all transactions going forward, the amount of revenue would be a fraction of going back retroactively and doing that. And that's really, in all of our discussions with Hill staff, and this is Republican as well as Democratic members, they talk about, oh, there's some kind of skullduggery going on here that we have to stamp out. But barely a breath later, they say, and besides, this scores well.
Yeah.
meaning there's some revenue there.
Let's see, but you could be morbid. It's so funny. I mean, it's just, and then that goes right against the Biden 30-30 plan and everything else. I mean, it's just,
Yes. And
yeah.
so the challenge is to make sure not that the main bill, this Daines bill, passes, because I don't think it would ever pass as a standalone bill. We've convinced enough lawmakers that this is a bad grant of power to an IRS that already needs some guardrails.
Yeah.
But they could very well hang it on, for example, the bipartisan infrastructure package. That's a few $1 billion of revenue, they can say, that offsets all the spending.
So speaking of that, what do you think? They're looking for to double the IRS's budget or operating budget, and I know you and I talked about that a little bit a couple weeks back. I mean, what are they going to do with all this money that they're getting? Is this like they're just going to step up these tactics they've been using? Is it something different? Do you have any idea?
Well, the goal of members of Congress, of course, again, is to generate a revenue return. And the administration, as well as some of the proponents in Congress, have said, well, $1 invested in enforcement will yield $6-8 of revenue to the Treasury. Historically, that's not true. It's more like $2 or $3. Enforcement is a very expensive proposition compared to voluntary compliance through public notices or better customer service. I mean, that, from our perspective, first of all, doubling the IRS budget is like dropping a V8 engine into an ox cart. I mean, they won't know what to do with all of that money to start with. We've benefited very recently from former IRS senior managers who've been telling us about how the IRS budgets and plans, and there is no way they can absorb that kind of money in a productive fashion, at least not over a 1 or 2 year period. It'd be 4 or 5 years minimum, and it's got to go in the right place. I mean, that was Ernie Dronenberg, the former head of California's equalization board, said that I can get about 5 to 6 times the rate of revenue return through voluntary compliance initiatives like more taxpayer notification and awareness than I ever can from audits. Start thinking that way. And Congress needs to start thinking that way. That's kind of the race against time that we're involved in right now, is making sure that kind of perspective gets to lawmakers. You know, you could wave a flag in front of them and say it's un-American to give this agency this much money, but you have to appeal to them on a more practical level. How will this work, and will it work? And what do you want out of this?
Yeah, I mean, from what I see is if we could just keep things out, you know, if you could keep things out of being so adversarial.
Yes.
Most people want to follow the law. I mean, I know some don't, but most people do. I mean, from what I've experienced as a CPA, believe it or not, most people don't cheat on their taxes, and they do want to pay their tax, and they would. But when they come at them like this, they get kind of scared, and then they get lawyers, and you know, there you go. It just starts pinging. So, yeah, I think that's part of it. It's just the climate of it. But yeah, I know we're running out of time here, so thank you for that, Pete. Really quick, I wanted to just kind of go around to I had kind of one more thing to ask about. And Walt, I'm going to ask you something. And I know that you got, you work a lot of investments and things like that. And I know you got FINRA to think about, so you may have to answer this carefully. But what are you seeing? Because I know you deal with a lot of private investors, high net worth people, that kind of thing. Talk to them quite often. I mean, can you offer any insight about just the climate, the chatter about what they think is going to happen to tax rates? Is it common that people think they're going to go up? Do they think they're going to go down? Are they deferring taxes? Are they doing different plays? I mean, what are you seeing out there? What are you feeling that might be kind of a trend, if you can answer that?
Yeah, thank you. Can you hear me all right?
Yeah.
Okay, great. So it seems like this year is a pivotal year. I think that, you know, businesses come back for a lot of high net worth individuals that own their own business. So I think you'll see an increase in liquidity events. I think you'll see with the lower interest rates staying where they're at, that'll feed private equity to be able to go out and acquire, these entities as well. And I think across the board, everyone expects their taxes to go up in the outer years. So that as well, I believe, is driving M&A activity.
Yep.
And then that's kind of a snapshot that I have.
Cool. What about you, Fen? You have any opinion on what you think is going to happen to taxes?
I think they're going to continue to go up, and I think the litigation, though, I think we're going to see some movement in this litigation that has to towards IDR or some sort of resolution short of full-blown fight it to the end in the court system. But I think there's no way they can't. I mean, economics 101, they print money like that, we're going to hit the 70s inflation, and taxes are going to go up too. Just to maintain the same value of the dollar. I mean, the same value per dollar. The dollar's going to be worth less, so they're going to have to bring more in, and they're going to have to keep scrambling for it.
Yeah,
and we see it in just the market right now for purchasing goods. Just had to buy my daughter a car, and a brand new car was cheaper than the used same car.
Yes, I've seen that. So who needs Bitcoin when they can buy used cars?
Yeah.
Right. And it's easier to calculate the taxes too. Pete, what do you think? I mean, I kind of agree with what Fen said, but I also that the legislation doesn't always follow what it needs to if the polls aren't there for it. So what are you seeing? What are you hearing about rates?
Whatever we expect is going to happen right now is not what's going to happen in the end. But taxes are likely to go up. The key question is, will they do so fairly, and will they do so understandably and transparently? Mm-hmm. And what all of us, including everybody participating in this session, do over the next couple of months could determine that. And I just make the pitch, please, if you're having experiences with the agency that you want to share confidentially, or if you have experiences as a former IRS employee, or if you're watching a case that you think we should be aware of for potential litigation purposes, contact me. I'm learning a ton, especially from those former IRS senior managers that I never knew these past 33 years. That can help us tremendously in making sure we get a decent outcome here.
Good point. Yeah, I mean, never thought of it. This is kind of a panel of superheroes fighting on behalf of taxpayers. I never thought of it that way, but now you just made me think of that. That's pretty cool. Yeah, so thanks, guys. So is there anything that, as we wrap up here, is there anything that I didn't ask today? We had lots of questions coming in, and I was trying to get to most of the stuff. Is there anything that you just wish you had been able to say that you want people to know? You only have a couple minutes here, but that you just want to make sure you get out before this is over. Please, I'm not going to call around on everybody, but please speak up now if you.
Yeah, I would just suggest that we're here as a service to advisors, tax advisors, CPAs, tax strategy folks. So if you have specific conservation easement questions or investments with potential to be conservation easement, give us a call, and it won't cost anything. We can hopefully address your question and enlighten you and give you just more insight so you can make better decisions for your clients and so forth.
Cool. Peter, Fen, anything?
I would reiterate the same thing. If we talked about subpoenas and whatnot, feel free. I mean, if it gets extensive, obviously I'm going to have to charge you. But to call and ask, hey, I've got this situation, I'm happy to talk to anybody, because this is something that is bigger than any one lawyer, any one firm, any one investor, and we all have our own perspective, but we've got to be able to have some degree of unified, or communication is a better word, between different people fighting this. I think this thing we've done today has been fabulous. I've learned a lot, and hopefully have helped some people understand some things they didn't already, that they hadn't had this outside of their area of experience. But we're happy to do whatever we can to kind of keep, help people make these tough decisions that they've got to have the information. And the people on this panel all have degrees of information or can point you to somebody that does. That's important.
Yep.
Yeah. All three of you are smarter than me in these affairs, but if anyone out there is interested in the policy aspects of tax administration, taxpayer rights, email me. You don't have to spell my last name. It's just president@ntu.org. That's all it is.
All right. Well, and I'll make sure that everybody has your contact information. My pledge to you guys is to get this in front of as many people as possible so that you can positively affect as many lives as we can. So we'll put a good effort into that. I appreciate all of your time. I'm grateful. I'm also very humbled by your investment of time here and very appreciative of it. And I know people that are on the call are also appreciative of it. But yeah, I think what you guys are saying here to wrapping it up is the right thing. Let's stay in touch. Let's keep communicating. Like you guys said, you guys have been great. You're very open to things. And of course we all have bills to pay and stuff, but before it gets to that, we'll help each other and we're all willing. So I appreciate you guys for that too. I appreciate your attitude and where your hearts are. So
Thank you.
With that, I'm going to wrap it up and have a great rest of the day. And thanks again, guys.
Thank you.
Appreciate it.
Take
Take
care.
care.